Hello, hello, hello. Hold on. How are you guys doing? I am. Find a way this dude. Okay. Attorney Montgomery, the small business attorney, coming to you live from River Region Automotive, where I'm getting my car serviced. I was not expecting to get those things done. I went in to another place for an oil change, and they were like, "Oh, your car's dying." And so I had to get a second opinion from some people that I trust. So I am here, and they are absolutely taking care of me. Hello, thank you. As you come in, put your name in the chat box and let me know that you're here. All right. So this is going to be a quick stream because, like I said, I'm not in my office. There's no chalkboard. It's just me. So, all right, let's get into it. So we're going to talk about, and I have my notes, three steps you can take to protect your ideas when you're working with investors and third parties. I'm part of many Facebook groups, and there was one. Hey, Keisha, thank you so much. I'm glad to have you. Thank you for joining me. And look, if you know anybody that could benefit from this information, definitely let them know that we are live. This is their opportunity, not just to watch the information, but to ask questions. So go ahead and invite them in. So we're going to do 3 steps to protecting your ideas when working with investors and third parties. And like I said, this came up because I was in a group where there was a Kickstarter campaign, and somebody apparently beat the Kickstarter to the punch, and they launched first, and they made all this money ahead of the Kickstarter. So everyone was like, what do I do? How can I prevent that? So these are the things you should know. Before we even get started, the main thing you should know is that there is no protection in ideas. What you have out here that hasn't been executed, there's no protection in it. So we're going to talk about how to address that and what to do, how to navigate. And the reason that this information is so important is because oftentimes you need help. You need help executing your ideas, but you want to be able to do it in a way where you don't get screwed over, right? So 3 things to do. The first thing is to register your intellectual property. Your intellectual property will be your patents, your trademarks, your copyrights, and you want to make sure that you own that and control that so that when you are working with these third parties, you don't have to worry about someone undercutting you and beating you to the punch. So let's say you have you're pitching an investment for a product, and it's a product that's it's a new product. It's new, non-obvious, and useful, so maybe it qualifies for a patent. You want to go ahead and get a provisional patent, which is like a pre-patent. It allows you to say that you have a patent pending and have priority over anyone that might come after you. So you want to be able to have that so that when you're going into these meetings, you can say that we have a provisional patent, and that also prevents them from being able to say, hey, we're going to take your idea, we're going to get a patent first, and leave you high and dry. If you have, let's say maybe you don't have a product, maybe you have a service, maybe you have a course or a workshop or a show or a program that you want to bring somebody in to work with you on. Maybe it's not an investor, maybe it's just a third party. Maybe one of the things you want to consider doing is getting an intent to use application, an intent to use trademark application. Because what an intent to use trademark application does is actually tell the world that, hey, I'm not using this now, but I intend to use it, and it gives you, again, priority over someone who might file an application for the similar mark after you. So that's one thing that's another thing you can do, is an intent to use trademark application. You don't have to wait until you're actually using it before you protect it. And it's a way, so if you're in negotiations, if you're talking to trying to come together, that way you can make sure that you own that intellectual property before anyone else does, and you can proceed the way you want to. And the same thing goes for, like, if someone is doing like an original work, maybe you are writing a book or you have a script and you're pitching it to different publishers, or maybe you're pitching it to different directors. You want to own that material. You want to make sure that you have the copyright for that. So once that work is created, you want to go ahead and register with the Copyright Office before you enter into those meetings to make sure that your intellectual property is protected. Thank you so much for the hearts. So that's number 1. Register and protect your intellectual property. Intellectual property, they're assets. They're absolutely assets, and they can be not only because it gives you Oh, thank you. Not only because it gives you the right to exclude others, but also when you own your intellectual property, now when you're going into these meetings, you have room to negotiate. Now that ups your ante, that puts you in a better position, and you can get more money and make sure whatever you're doing, it brings more value to it. So number one, register your IP. Number two, I always say, use your written contracts. Put it in writing. Whatever you're doing, you put it in writing. So if you go into this meeting and your intention is for them not to put the information out anywhere, use an agreement to do that. And I can't stress the importance enough of using written contracts. And while written contracts, they can't, they're not a guarantee. Some people say, well, why should I use written contracts? You're right, they're not a guarantee, but what written contracts do is they deter the other person from breaching the contract. If they know that you have a remedy to make them do what they said they would do, they will go ahead and do it 9 times out of 10 because they want to avoid all the legal costs associated with it. With that being said, the thing you have to know about contracts is that it's a contract. You have to make sure that you trust the person that you're entering into the agreement with. If they don't have a good reputation, if you don't know too much about them, you might want to keep your work and your ideas to yourself until you can vet them. Because if you don't know anything about them, you don't know if they're going to adhere by the terms of the contract, and if you can even, and if it'd be worth going into it with them. Let's see. So if that's the case, why do it? Because it creates a paper trail. You get a paper trail, and if you have a paper trail that states about what you guys agreed on, when you get to court, the judge will know exactly what they need to do to make the other person, and what they need to make the other person do. So in this term, when you're trying to protect your ideas, and when you're working with third parties, you want to use things like non-disclosure agreements, which says that, hey, I'm giving you this information for this purpose, and it's limited to this. You cannot share it. You want to use things like non-compete agreements that says that we're in negotiations, we're talking. You can't take this idea and run off with it at your own. And when you're talking about these contracts, some of the things that you need to make sure you include in your contract, which is very important, you need to discuss, what constitutes a breach, and what would happen if they breach. If they do share your information, what are your remedies? You need to be very clear on that. And the third thing, let's see, I have notes. Oh, the third thing is so obvious. Keep your mouth shut. Keep it to yourself, because remember, ideas cannot be protected. So you have to keep those things to yourself. If you have something that's going to give you an advantage over your competitors, whether it's the process or a system or method or a client list or email funnel or whatever it is, keep it to yourself. Those things are called trade secrets, and they are valuable. But the thing about trade secrets are you can't register them, because if you register them, it's going to make a public record, and then all of a sudden it's not a secret anymore, right? So the only way to protect those things are keeping your mouth shut, so that the information doesn't get out. And again, if you have to talk to someone, have to bring other people in, make sure you use your written contracts, and make sure you limit who you talk to. Everybody doesn't need to know. You don't need to tell your cousin, you don't need to tell your mama, you don't need to tell, and even in your business, everybody doesn't need to know those things. Because what you don't want to do is have to keep up with the information that was out and who has access to it, and how you can control them from letting it out. All right? So 3 things. Those are the 3 things. Those are my 3 tips. And I know this was a really quick video, but that's just like I said, I'm not in my office. I'm sitting at the auto shop getting my vehicle fixed. So if you have questions, let me tell you this thing. If you have questions that are specific to your business, you can absolutely schedule a time to talk with me. You can go, if you're on Facebook, you can hit the Learn More button, and schedule a complimentary 10-minute discovery call. If you want to learn more about, trademarks and protecting those trademarks and protecting those copyrights, because I will tell you this, And you see it all over my page. Ignorance is not an excuse. If you are in business, you have a responsibility to understand what constitutes infringement and what doesn't. You are responsible. Let's say you hire a graphic designer and they go and they right click and they use elements from someone else's, and so they're infringing on someone else's copyright. You need to know that. You need to know what constitutes infringement so you can say, hey, I can't use your work. Because ultimately you might be held responsible. I have courses on that right now. Those courses are dirt cheap. I'm just going to tell you, you will never see this price again. It ends today. The price is only $249 for the ultimate trademark do-it-yourself blueprint and the copyright masterclass. I'm telling you, you need to check it out simply because it's a great price, and it's going to teach you, when it comes to trademarks, it's going to teach you what can and can't be protected. It's going to teach you how to do a comprehensive federal trademark clearance search and how to complete your application. On the copyright side, it's going to teach you again what can and cannot be protected, how to do your application, and we're going to talk about what to do if someone infringes on your copyrighted material. We're going to give you templates for cease and desist letters and how to DMCA takedown notice. So you can get that information at courses.offthemarkipsolutions.com and find the copyright trademark bundle. All right. Any questions?
Here. Can you give me a set of those DG1440?
All right. I'll talk to you later.
1440. Chris Collins.